واختلاف الليل والنهار لآيات لأولي الألباب الذين يذكرون الله قياما وقعودا وعلى جنوبهم وقعودا وعلى جنوبهم ويتفكرون في خلق السماوات والأرض ربنا ما خلقت هذا باطلا سبحانك فقنا عذاب النار ربنا إنك من تدخل النار فقد أخزيته وما للظالمين من أنصار صدق الله العظيم. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Ladies and gentlemen, the next is singing the national anthem of Indonesia Raya and followed by hymn of Universitas Islam Indonesia. To all participants, all rise. Hadirin dimohon untuk berdiri dari tempat masing-masing.
Yes,
Please be seated. Hadirin dipersilakan duduk kembali. Ladies and gentlemen, the next is the opening remarks from the Rector of Universitas Islam Indonesia to Professor Dr. Fatul Wahid, ST, MSc, PhD. Time and place are yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Wa syukur ala ni'amillah wa salatu wassalamu ala rasulillah Muhammad ibn Abdillah la hawla wa la quwata illa billah. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Good afternoon to everyone. And honorables, the speakers, colleague, and all the participants of this international conference. First of all, it gives me a great pleasure to welcome you all in this conference, which pay attention to very relevant issues we are facing today, which is mutual legal assistance and asset recovery, a comparative study in the legal system of Indonesia, Malaysia, Myanmar, and Hungary. On behalf of Universitas Islam Indonesia, I would like to congratulate the Faculty of Law, Universitas Islam Indonesia, for arranging this international conference. And to me, which come from another discipline, without a law educational background, when learning the term of references sent to me by the community, I came up with at least 2 issues that are interesting to be discussed or that can be used to frame the discussion. The first issue is that now we are living in the borderless world, where the border between states has become blurred, and the recent development taught us that in many cases we are not able to escape from the understanding that we may face cross-border legal issues. That's why developing mutual understanding in many fronts, in many cases, is very important. In one case, we may develop like a multicultural understanding. But in this context of our conference, we will discuss the mutual legal assistance, which is somehow challenging on one hand, but at the same time, it will also broaden our perspective. This is one issue. The second one is, I do believe that although all the national legal system depart from different contextual specificity, but I do believe that they will share some commonalities. And I do believe that the communities can be further scrutinized and can be identified to set up what we can call a common ground. Because what I learned from the term of reference sent to me, that there is no single agreed standardized legal procedure in the mutual legal assistance. So if we can learn to, among each other with Indonesia, Malaysia, Myanmar, Hungary, I do hope, and we can find like a red thread that can serve as a springboard to collectively progress. There's the two issues that I would like to share with all the participants, and we do hope that borderless world and commonalities can be used as a starting point to set more more agreed standardized legal system. In this context, we can refer to the mutual legal assistance and asset recovery. Again, we thanks to all the speakers and all the participants, and I wish that you will find this conference rewarding and insightful. I thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you for Professor Dr. Fatul Wahid, ST, MSc, PhD, for the opening remarks. Ladies and gentlemen, before we start our main agenda, let us hear together the keynote speech from Mr. Cahyo Rahadian Musar, SHLLM, the Director General, General Law Administration, Ministry of Law and Human Rights, Republic of Indonesia. Mr. Cahyo Rahadian Musar, SHLLM, got his Bachelor of Law from Faculty of Law, Universitas Indonesia, and got the Master of Law, LLM, from the University of Nottingham, United Kingdom. To Mr. Cahyo Rahadian Musar, LLM, time is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Good afternoon. May peace be upon us all. Distinguished speakers, Rector of the University, Universitas Islam Indonesia, Professor Dr. Fatul Wahid, ST, MSc, PhD, Deputy Chief of Cabinet of the Ministry of Justice of Hungary, Associate Professor Dr. Saba Gondola, representatives from the Attorney General Office of Malaysia, Tuan Norina Bahadun and Tuan Faizul Aswad bin Masri, lecturers from Universitas Islam Indonesia, Professor Dr. Sefriani SHM Hum, and Associate Professor Hanafi Amrani SHMH LLM PhD. Lecturer from Multimedia University, Malaysia, Associate Professor Su Wain Mon, LLB, MCL PhD. Legal Attaché from the Attorney General Office at the Indonesian Embassy in Singapore. Participants, ladies and gentlemen. It's an honor for me to deliver the keynote address of the International Conference and Call for Paper Mutual Legal Assistance and Asset Recovery, Comparative Study in the Legal Systems of Indonesia, Malaysia, Myanmar, and Hungary. It has been more than a year we equally struggle in the face of a global pandemic, which leads to global economic setbacks. Currently, our government, including governments all around the world, is trying to widen the vaccine administration rate. And in Indonesia itself is expecting more than 50% rate by the end of July 2021. I would like to remind every participant to not hesitate about the effectiveness of the vaccine and to apply for the vaccination at the nearest state health facilities. Ladies and gentlemen, the increasing international mobility of offenders and the use of advanced technology and international banking for the commission of offenses make it more necessary than ever for law enforcement and judicial authorities to collaborate and assist each other in an effective manner in investigations, prosecution, and judicial proceedings related to different offenses. As we understand that international legal cooperation, the effectiveness of international legal cooperation depends fully on two factors. The first one is how the legal process in the requesting country is done in accordance with their respective national laws. We know that mutual legal assistance, the scope of works in the context of mutual legal assistance include all legal actions starting from the stage of investigations, prosecutions, and the execution of a binding decision, a binding judgment. So it covers all types of legal actions within those two stages within one legal process. We understand also that there are requests that needs to be taken with enforcement powers, and those that can be given or provided for by the requested state by means of voluntary basis. The effectiveness of international legal cooperation in this context through the means of mutual legal assistance, as I mentioned before, depends on two factors. One, in the requesting state. The requesting state has to ensure that all actions are taken in accordance with the laws and regulations, in particular, the code, criminal code of each of the respective jurisdiction, in this case, the requesting country or the requesting jurisdiction. With that in mind, and with the fulfillment of those requirements under the criminal code of the requesting state, then we have fulfilled, or we have come up to the stage where this request can be made to the requesting country. And in drafting the mutual legal assistance, although I understand that in this case I'm supposed to make an opening remarks, but I'd like to share with all of the participants the practices, the best practices of Indonesia in making legal assistance request as a requesting state, or receiving, how we process mutual legal assistance requests in Indonesia, and ensure that the process is in line with domestic law of the state requesting state and the domestic law of the requested state, and also in adherence with the existing international laws and regulations, including, in this case, bilateral, regional, or multilateral arrangements. We understand that we have at least three legal bases for states to cooperate. Those are the means that I mentioned earlier: bilateral, which states conclude between two states, and then regional, whereby we have, for example, the ASEAN Mutual Legal Assistance Treaty within the region of ASEAN, and also in other countries and other regions of the world and other parts of the world. They also have their own regional treaties or conventions. And of course, most countries in the world who are active in this type of cooperations are very well aware, and also members or states parties to the existing international conventions like the ANCAC, UN Convention Against Corruptions, and the UN Conventions Against Transnational Organized Crimes, and also the 2 drugs conventions. So fulfillment of the domestic requirements, fulfillment of the requirements under existing treaties, be it bilateral, regional, or multilateral, and also the requirements under the domestic law or national law of the requested state is a must, something that has to be fulfilled. Otherwise, we can always say, why do we have to be so strict in fulfilling these requirements? The answer to that question would be admissibility issue. Because any request made under mutual legal assistance, if it is not made in accordance with the domestic laws, either of the requesting state or the requested state, or under the existing international conventions, would be unadmissible when it is used for the purpose of investigations or court proceedings in the requesting state. So these are the requirements that need to be fulfilled. Ladies and gentlemen, we know also that international cooperation is something that we have to continue pursuing. We understand the nature of crimes, especially transnational crimes, develops as we speak. Crimes have always been history proves that crimes are always 2, 3, 10, maybe 100 steps in front of us. Laws and regulations have always been left behind by the development and the sophistication of crimes. So therefore, international cooperation is something that we have to develop and nurture, continue to nurture, and continue to talk to each other to discuss on how we can keep up with the development of crimes, especially transnational crimes. So that's why we have forums like the existing various international conventions, state parties, conference, whereby Indonesia and also other countries, participants who are participating in this very important conference, and also one participant from Europe, Hungary. Those are the forums where we can exchange views, exchange experience to discuss on how we overcome hurdles and challenges of international cooperation. Indonesia itself is a party or parties to all of the international conventions, UNCAC, UNTOC, Drugs Convention. So our approach, Indonesia's approach, in the context of international cooperation, particularly mutual legal assistance, is to always share our experience in those very important events. And we develop communications with other countries states parties to the convention and non-state parties to the convention to ensure that we have a convention or a forum that is always updated and ready to provide answers to challenges that we face in our international cooperation. One of the other key to the success of international cooperation is, of course, political will of the countries, the requested country, the requesting country. With the absence or no political will, there will never be an effective international cooperation. So the means to achieve an effective international cooperation does not just lie on the fact that we have legal grounds in the form of treaties, but also the effective communications between central authorities of the countries in question. Central authorities acting as the facilitator, if I may use the word, term facilitator, of law enforcement agencies who are seeking assistance from other countries. As an idea or a proposal, I think we should always open effective communications between central authorities and also between law enforcement agencies, which can take part based on the existing forums that we have, or create other forums as a platform or a forum for us to communicate further. If you analyze the existing forums that we have, central authorities and law enforcement officials or representative of governments who are involved in mutual legal assistance cooperation meet only, if that happens, meet only at the most once a year. That is not enough for us to be able to discuss in detail and have an in-depth discussions on the various issues that we are facing based on the cases that we have. Indonesia has started to develop central authority forums bilaterally with other countries, whereby we meet at least once a year and we bring cases, pending cases. We discuss on challenges that we face in international cooperation, including working with other jurisdictions. And we even discuss issues such as efforts to reform the platforms that we have, reform the conventions, the clauses in the conventions. If we look at the existing conventions, those conventions only state or only governs the principles in mutual legal assistance. Look at the UNCAC, UNTOC, the Drugs Convention, you can see that mutual legal assistance is only discussed in general. So therefore, forums should be developed, or existing forums should be activated further. In this forum, in this very important forum, I'm hoping that there will be inputs based on experience, based on academic research and studies, because this involves the academy, the universities, and based on the discussion from practitioners who have been involved directly with drafting or receiving mutual legal assistance requests, and also scholars from the university who have studied or who have the expertise in international cooperation, particularly mutual legal assistance, can have a discussion based on the experience of the practitioners and also from the expertise of the scholars to ensure that we have a more workable and effective means of cooperation in the form of mutual legal assistance, and develop also a mechanism that can facilitate the effectiveness of the international cooperation, in particular mutual legal assistance. With this in mind, I hope that all of us can have a productive discussions, and we are looking, of course, forward to future events like this, where we can finally have a more effective cooperation in mutual legal assistance, where we can also submit the recommendations to our respective governments, and also then our respective governments through the international forums such as the UN States Parties Convention, as a part of our effort to make the States Parties Conference on mutual discussing on the particular issue of mutual legal assistance to come up with breakthroughs for an effective mutual legal assistance. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Warahmatullahi wabarakatuh.
Thank you for Mr. Cahyo, Radian LLM, for the speech. Please give our warmest virtual applause to our keynote speaker. Ladies and gentlemen, before we start to our main agenda today, we would like to announce to all participants, please turn on your video camera and mute your microphone during the session. And we also would like to announce that the attendees will be delivered in the end of the session. Jadi kami menginformasikan kepada seluruh peserta bahwa dimohon untuk menyalakan video kamera ketika sesi berjalan, dan untuk daftar hadir akan didistribusikan pada akhir sesi. Ladies and gentlemen, now let us start our main agenda today, the International Conference and Call for Paper, Mutual Legal Assistance and Asset Recovery, a comparative study in the legal system of Indonesia, Malaysia, Myanmar, and Hungary. Please let me invite our moderator today, Dr. Anda Sriwartini, SHMH, PhD. She is senior lecturer on international law at Faculty of Law, Universitas Islam Indonesia. She got her bachelor degree from Gajah Mada University in 1987, Master in Law from Universitas Pajajaran in 2003, and PhD from International Islamic University, Malaysia in 2012. Her expertise is on international law, international environment law, and international civil law. Ladies and gentlemen, Dr. Anda Sriwartini, SHMH, PhD.
Assalamualaikum warahmatullahi wabarakatuh. Thank you very much, Master of Ceremony. Good afternoon, ladies and gentlemen. The honorable keynote speakers, today that we are going to have the presentation for the distinguished speaker. But before we start with our discussion today, I would like to greet, there are some guests here, very respected guests. First to Mr. Cahyo Rahidian Moschar SHLLM, the Director General, General Administration, Ministry of Law and Human Rights, Republic of Indonesia. All the distinguished speakers and also the Honorable Rector of Universitas Islam Indonesia and the Honorable Dean Faculty of Law Universitas Islam Indonesia. Today we are going to have an important event. We are going to discuss about the mutual legal assistance and asset recovery, a comparative study in the legal system of Indonesia, Malaysia, Myanmar, and Hungary. In the era of globalization and the development of technology has changed the character of organized and extraordinary crime. One of the extraordinary crime is corruption. I do believe that corruption has threat of serious impact to the society. It's undermined democracy and the rule of law, lead to the violation of human rights, destroy the quality of life, and even export organized crimes such as terrorism and other threat of human security to flourish. Corruption is rapidly expanding globally. The lack of empirical evidence on corrupt scheme and imperfect dialogue between different disciplinary areas and between academic and practitioner hinder our knowledge to corruption as a global phenomenon and slow down the adoption of appropriate policy responses. In order to combat corruption in global level, the United Nations on Drug and Crime adopted the International Crime Against Corruption. It contained legal instruments to respond to global problems, such as mutual legal assistance and asset recovery. The corruptor hide their assets in other states in order to avoid the confiscation of their assets. It is particularly fatal for developing countries when their national welfare has already corrupted and exported to other countries. Once stolen assets are transferred to other states, recovery is extremely difficult. There are several barriers to asset recovery. In developing countries, this difficulty results from the limited legal, executive, and also judicial capacity, as well as inadequate resources. Further, the lack of resources affect the ability of states to make requests to countries holding the stolen asset. The problem is worsened in developed countries where assets are hidden or where necessary law may be lacking to respond to requests for legal assistance. Hence, international cooperation is essential for the successful recovery of the asset that had been transferred or hidden into foreign state. However, it will be required for gathering of evidence, the implementation of professional measures, and the eventual confiscation of the pursuit and instrumentalists of corruption. When the asset is confiscated, so cooperation is critical for their return. International cooperation include informal assistance, mutual legal assistance requests, and extradition. Informal assistance is often used among counterparts agencies to gather information and intelligence to assist in the investigation and to support strategies for forthcoming procedure for recovery of assets. That's why today we are very happy that we all have all of you to be here. And before we start with the first speaker, I would like to have the announcement for all the distinguished speaker and also for the participant. First of all, that each speaker will have 20 minutes to present the paper. And I would like to give the reminder 5 minutes before the session is over. And know that we are going to start with the distinguished speaker. First is Mr. Yulfitri Adiaksana. He is a career prosecutor who had been working at the Asset Recovery Center Attorney General on 2015 and also 2019. And currently, he is a legal attaché embassy of the Republic of Indonesia in Singapore. Before he starts with the presentation, I would like to read the brief CV of Mr. Yulfitri Adiaksana. The education background that undergraduate he got from the Gajah Mada University from Faculty of Law, and he got master degree of law in University of Washington Seattle, and the next also Magister Hukum from Diponegoro University. So without further ado, that I would like to request Mr. Yulfitri Adiaksana to have your presentation time as yours. Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Selamat siang, salam sejahtera. Very good morning to our colleague from Hungary. Bismillahirrahmanirrahim. Terima kasih Ibu Sri Wardani PhD dan yang kami hormati Bapak Rektor, the Honorable Rector of Universitas Islamic University of Indonesia, UI Bapak Profesor Dr. Fatul Wahid, and the Honorable Dean of Law Faculty of UII, distinguished experts from Aegis Chambers of Malaysia, expert from Myanmar, and the speaker from Hungary. Yang kami hormati, distinguished ladies and gentlemen, and the most important keynote speaker, Bapak Director General of Administrasi Hukum Umum, General Administration, General Legal Administration Matters of the Ministry of Law and Human Rights, Bapak Cahyo Rahardian. Bapak dan Ibu sekalian, ladies and gentlemen, students and academias, thank you very much for the organizers to invite me to this important international conference. And I am speaking based on my experience when I did the job as the head of transnational asset recovery back 2 years ago in the Attorney General's Office of Indonesia with the Asset Recovery Center. So although my capacity now is legal attaché, I'm going to present this presentation based on my knowledge and experience on my works in the Asset Recovery Center, the PPA Kejaksaan. And well, I thank you also my classmate, Professor Sefriani, and I would expect last minute actually in dealing with the things kind of when we are trying to buying things and then we get last minute deal. That's a good one. So I would not expect a last minute deal in this kind of circumstance. But anyway, Alhamdulillah that I'm able to now presenting my slides on the Indonesian legal frameworks on MLA and asset recovery. And I would like to begin with the next slide, please. My points of presentation, please just show all of the points. Ya, tolong ditampilkan semua. Okay. So I would like to address the issues of Indonesian legal system, the main global framework for Indonesian asset recovery, and then the MLA law and asset recovery, formal and informal cooperation, challenges on transnational asset recovery, and then a brief conclusion for what I have presented. And I would like to highlight what Pak Cahyo, Pak Dirjen, saying about 30 minutes ago, the importance of practicing domestic rules and law and regulation when you are requesting a MLA request. So you need to ensure that you are comply with your own law and regulation. And of course, as addressed and highlighted as well by Pak Rektor, Bapak Fatul Wahid, that we are living in the borderless, more borderless era, where you would have legal issues and cases involving stolen assets, whether it's from corruption or it's from the proceeds of other crimes, that crossing your jurisdiction and crossing your border. So you need to really you need to do your best to get the similarities and also to have something in common to make it productive to everyone, but mostly to the victim of this stolen asset, which is normally will be the requesting state on the MLA, mutual legal assistance request. And I would like to move to the next slide because my time I think is 20 minutes. Next slide, please. So dibuka semua saja. Yeah. Indonesian legal system basically modeling Dutch civil law system. I will not going to elaborate this, but significant changes in KUHAP. We call it KUHAP. I understand that there are many students who are now in this Zoom meeting. So I'm trying to, well, sometimes I will speak in Bahasa Indonesia, but also I'm mostly speaking in English, but I would like, I'll try to address issues so open that could open the mind or could open the horizon for the students to make further studies in the area of asset recovery, in particular the one that in connection with the mutual legal assistance. So Indonesian passes law to ratify a convention. I understand that this conference, international conference, is a collaboration between the international law department and the criminal law department. So ratification, the convention is more on the international department domain. But I would like to address that in Indonesia, there is no automatic application of a convention. So we ratify a convention, but in practice, we need to incorporate the provision into a specific law of our domestic legal system. And this is sometimes could end up in an issue of the implementation of international commitment or obligation by Indonesia. Next slide, please. We have a global framework, actually, the international obligation. So if you are interested in knowing more about the asset recovery and the connection with the money laundering, then please read the 40 FEDEF standard or 40 recommendation, which address the technical compliance and effectiveness of a jurisdiction, a country such as Indonesia, to this global recommendation. And also, ANCAC is a good example of a convention who provides comprehensive guidance on the asset recovery. Please understand that the provision in ANCAC is more on the guidelines. It's not really a hard law when you are violating a convention or provision on the convention, and then the UN security forces would come to your jurisdiction. It's not like this mechanism. This one is more on the soft law. So it's more on the guidelines, how to address or to regulate your legal system adapted with the asset recovery on the UNCAC asset recovery provisions. MLA as well is governed in the UNCAC. But also, as mentioned by Pak Cahyo, Pak Director General, is the regional treaty and the bilateral MLA treaty. Next, please. And now we talk about the Indonesian MLA law and asset recovery. We have the law number 1 year 2006, where I also participated as one of the members of the drafting team at the time, because we have a joint multi-agencies drafting team in 2005, and then we managed to finish the draft and then send it to the line, along the line in the law making process, and we then got the law number 1 year 2006. So the central authority is the Ministry of Law and Human Rights. It's a directorate under Pak Cahyo in the Ministry of Law and Human Rights, Kementerian Hukum dan Hak Asasi Manusia. And the competent authorities is like Kejaksaan, my office, Attorney General's office, KPK, as well, law enforcement. And I would like to highlight the scope of our MLA, Indonesian law on MLA, which has a connection with the asset recovery. The first one is the Article 3, Paragraph 2, and this one is more on the seizure, confiscation of proceeds of crime, and the how to pay fine, how to we try to confiscate and force convicted person to pay fine, so bayar denda. Please dibuka semua. So this is more on the seizure, confiscation. Common law countries, such as perhaps the members of the Commonwealth countries, would not saying, we have no terminology of asset forfeiture if we talk about Indonesian context, because we only know the two process along the way. I will talk later about the stages, but seizure and confiscation. So forfeiture is a bit unique because it belongs to other jurisdiction. So it's not really fit when we say we have forfeiture in Indonesian legal system. Well, of course, that could be more contextual. It depends on the context. But I think in general, we translate perampasan asset as asset confiscation rather than asset forfeiture. So these are the true scope, the three scope of MLA requests. So executing search warrant and forfeiture of proceeds of crime. I get the translation from the internet. So because of their background, they put forfeiture. So it's more understandable for people coming from the common law or other jurisdiction. But for us, Indonesia, we prefer to use confiscation. And the other one is on compensation. Why there is also scope and object of the compensation. This is because, among others, we recognize uang pengganti. Uang pengganti is really hard to get English translation, but I think I would prefer the compensation. It's much easier for us to understand. Because uang pengganti could be directed towards the lawful assets. So when you obtain an asset, when a criminal obtain a lawfully obtained assets, that could be confiscated under the concept and the mechanism of uang pengganti, compensation. This is one of the different feature of the anti-corruption Indonesian law. So the MLA covers those kind of things. Dibuka ininya mas, terus next, yeah. And also this is only with the compensation. Next slide. So this is just the brief overview of the asset recovery stages, which I always put this slide when I talk to the audience, mostly the practitioners. So my presentation today is a bit different because I'm talking with the academias, with the students, with the researchers. So I have no tips this time. Normally, I would suggest any tips or strategies for the best practices on asset recovery or MLA requests, because I have those kind of experience from the drafting of the MLA request, together with Pak Cahyo as well, when we are including when we were in the Switzerland, in connection with the request of the NELU, the freezing of asset of belongs to the late HCW NELU. And also I did negotiation on the MLA treaty. So I think based on those kind of thing, I could then suggest best practices or tips and strategies if you want to get more effective MLA and asset recovery requests. So you can see that confiscation and forfeiture actually are similar, but please translate the Indonesian law into confiscation for perampasan rather than the forfeiture to avoid misconception or misunderstanding of the legal term. Next slide, please. So what are the Indonesian experience recovering criminal assets? I'm not the people from the central authority, the Ministry of Laws and Human Rights, but because of we have tim terpadu, tim pemburu koruptor in the past few years. So I managed to get experience working with the one from the Ministry of Laws and Human Rights with the PPATK, the Financial Transaction Reporting Agencies, with the KEMLU, the Diplomats Corps, and also with other agencies, the police as well. So I am picking up the cases, important cases that in our history managed to get the asset back to Indonesia. At least when we talk about the Kartika Tahir and Pertamina case, because it happened during Pak Harto era and also it's a long time ago, my research did not know where the money actually went. I mean, the result of the winning of Indonesian government in Singaporean court. But that is the example of civil litigation. It's not MLA. MLA, we have few small cases. In Guernsey, we have civil litigation cases. Also, the money still sit in the bank. And when I was in the PPA, the Asset Recovery Center, I worked closely with my colleague from Guernsey, the state attorney, the prosecutors from Guernsey about this money, and now it's still sitting in Guernsey and become one of the example of a good case to learn a lesson, because the decision of the Guernsey court addressed, among others, the weakness of Indonesian government when requesting the repatriation or the confiscation, the return of asset sitting in Guernsey to Indonesia. It's good for study. I think masters, or PhD study could also look into the litigation between the government of Indonesia and the Garnet company belongs to Pak Tommy Soeharto, Utama Mandala Putra. And of course, the one that...
Excuse me, Mr. We will still have 5 minutes to finish.
Okay, yeah, thank you. Thank you, Ibu. So we have also ongoing MLA requests in the countries such as Hong Kong and other countries. The central authority is the one who knows this kind of thing, so I will not going to elaborate as well because my time is also limited. Next slide, please. So we have the formal the formal forms of international cooperation in asset recovery, MLA, and the treaties, including UNCAC as the multilateral treaties as a legal basis to request an MLA if there is no MLA treaty yet. So if in the case of there is an absence of MLA treaty, we can use the UNCAC as a basis to submit the request to other jurisdiction. Next slide, please. And also the informal, I think it's it's very important to address these issues, and also very important to study further this area, because I think the informal cooperation is sometimes overlooked, but it helps so much when we are having international cooperation. So I have put on the list the example, and especially on the asset recovery networks, we have the IRIN AP asset recovery, but the mother of this regional style body, the CARIN regional style body, is the Camden Asset Recovery Intelligence Network, which located in Europe. So they have their headquarters in The Hague. So this is the one that the ARC, Asset Recovery Center, Attorney General's Office, is the focal point. Both members of the IRIN IP and also in the CARIN. And now I would like to move to the next slide to address the examples of informal sharing of information. So we can start for the less sensitive things like getting company records and other registration. Next slide, please. So those are examples. And what are the challenges in transnational asset recovery? I think it is important for academics, for students, for researchers to understand what are the challenges and trying to get a solution, or at least to address these challenges. First, the differences legal system that may lead to differential legal terms and criminal proceedings. Remember that I mentioned about the confiscation and also the forfeiture. And also, secondly, there is no prosecution or civil suit was filed against the owner of the asset. This is lesson learned from the Guernsey case, because Indonesia is not pursuing asset belongs to Pak Tommy Soeharto elsewhere and in Indonesia, so Guernsey would not release the money. And the third one is the requesting state doesn't have solid coordination and cooperation domestically. So among themselves, we don't have a solid coordination. That could be a challenging one. And lastly is no effective informal exchange of information issues. So only use the formal, but no elaboration on the implementation of the informal networks. For instance, the informal exchange of information like company records, the one that I mentioned before. So in conclusion, and the last one is the gaps exist between the people in charge, like the gaps in knowledge, skill, language, because you have a different type of legal system and also different culture and different language. So you might have this kind of things as challenges to the asset recovery efforts. And in conclusion, because my focus is on the opening area of study, so I would like to emphasize that MLA is not single method to recover stolen asset. There is a civil litigation, there is an arrangement, there is informal networks. So there is another avenues to recover stolen asset. And legal frameworks need to adapt with the global development. But lastly, informal cooperation will have asset recovery effort as a complement to an MLA request if you have one on your way to trying to recover the stolen asset. I thank you for the attention, and Alhamdulillah. Wassalamualaikum warahmatullahi wabarakatuh. Selamat siang. I would like to give the floor back to Ibu Moderator. Thank you very much.
Thank you very much, Mr. Yulfitri. So you are on time. Thank you. It was a very interesting presentation, and also give us some kind of knowledge and experience that you have already shared. And however, that the participant would like to explore the best practice from Pak Yulfitri, you can ask question using chat box, or you are going to raise hand and directly to ask question. Now we are going to have the second speaker for this conference. The second speaker, it will be had by Professor Sefriani SHM Humes. She is a senior lecturer of Faculty of Law, Universitas Islam Indonesia. The title of her presentation is Mutual Legal Assistance and Asset Recovery from the international law perspective, best practice and challenges in Indonesia. Before she would like to start with the presentation, I would like to, yes, just to read about the brief CV, because if I read on the CV, will spend a long time. So on the complete CV for all the distinguished speaker will be available on the chat room. Okay, so the background of the education of Professor Sofriani. So she got the bachelor degree at Faculty of Law, Universitas Gadjah Mada, and she got master degree from Universitas Pajajaran, and she got the doctoral degree from Gadjah Mada University, and he became the professor in 2018. I think it's the short, brief or short CV from Professor Sefiani. So the time is yours, Prof. So you have 20 minutes, and I will remind you 5 minutes before the session ended. It's the floor for you.
Thank you for moderator Ibu Sri Wartini. Assalamualaikum warahmatullahi wabarakatuh. Honorable Director General Law Administration, Ministry of Law and Human Rights, Republic of Indonesia, Mr. Cahyo Rahadian Musar. Honorable Rector of Universitas Islam Indonesia, Honorable Dean of Faculty of Law, Universitas Islam Indonesia, Honorable Head of Program, Faculty of Law, Universitas Islam Indonesia, Honorable all invited speaker today from Hungary, Myanmar, Malaysia, also my friend from Embassy of Indonesia in Singapore, Mr. Yuswitri Adiaksana. And also all seminar participants that I very appreciate. Alhamdulillah wa syukurillah, so glad we meet in this international conference in the healthy condition. Ladies and gentlemen, according to the term of reference from the committee, I was asked to discuss MLA and asset recovery from international perspective, best practice and challenge in Indonesia. Ladies and gentlemen, let me present my main point. This is my outline. I divide in 3: introduction, MLA best practice of Indonesia, also the challenge of MLA in Indonesia. I start from introduction. Introduction. Next slide. Next. Ladies and gentlemen, corruption is the example of transnational organized crime or TOC. This crime was seen as serious threat to global security. The UN affirmed that corruption has caused massive poverty and degrades human dignity. Corruption has taken on an international dimension in recent years. It has been common for the corruptor to hide or launder bribes or embezzle funds in foreign jurisdiction. They are seek safe haven in foreign country. Because of limitation of state jurisdiction under international law, consequently, we need for international cooperation to fight and repress corruption more effectively. Next. This is for international cooperation. Ladies and gentlemen, we have several forms of international cooperation to fight TOC, such as MLA in criminal matter, extradition, transfer of criminal proceeding, also transfer of sentenced person. Unfortunately, until now, Indonesia doesn't have any positive law concerning transfer of sentenced person and transfer of criminal proceeding. While MLA governed in Law Number 1, 2006, and extradition governed in Law Number 1, 1979. Next. Ladies and gentlemen, MLA treaty is different with extradition treaty. Generally, it can be stated that extradition focus on pursuing the suspected or convicted person. while MLA focus on pursuing the evidence, provide assistance to other states and gathering legal document, financial document, and maybe other evidence in crime cases, including give facility to asset recovery, but not to extradite the person. However, it is interesting that some extradition treaty in Asia Pacific, such as bilateral extradition treaty between India and Mongolia, contain provision of MLA in their extradition treaty. Next. Why MLA in criminal matter, especially in asset recovery, is needed? There are some argument to answer this question. Because of international mobility. Like Ibu Moderator already explained when start this conference. For international mobility, because advance on transportation, communication, information technology, as well financial technology, cause the movement of people and asset of crime cross border rapidly. This condition give impact to the increasing number of transnational crime. The second is MLA is needed to overcome barriers of sovereignty and difference of legal system, and also we need MLA because of the related with the concept of follow the money. This concept, based on this concept, trace and asset recovery will be prioritized than searching for the corruptor. Return state money stolen by the corruptor back to home state. This is very important to recover state losses. Next. This is the scope of MLA. I think Pak Yuswitli already explained about this. So I not repeat the scope. Next. Because the time is limited. And this is a legal basis for MLA. For the legal basis, we can divide into treaty-based cooperation and non-treaty-based cooperation. For treaty-based cooperation, we can divide in three: bilateral, regional, and multilateral. For bilateral, is often conducted between neighboring jurisdiction or state that have close relationship with us. For example, bilateral ML in Indonesia is prioritas for countries that are become center of financial transaction, has a high intensity relationship with Indonesia, and Indonesia has big interest in asset recovery. For example, MLAT with Switzerland. While but the MLA regional treaty such as ASEAN Mutual Legal Assistance Treaty, this is maybe more efficient than bilateral treaty, because one treaty covered 10 states. And also, but for the multilateral treaties such as UNCAC, UNTOC, this multilateral treaty is not MLAT specifically, but they have provision that give order to state party to rendering legal assistance. What should be emphasized in this scope of multilateral treaty is narrower than bilateral MLA treaty in criminal matter, because multilateral cannot be used for all type criminal matter, but only for the certain crimes regulated in that treaty. For example, UNCAC can be used for corruption only. And also, ladies and gentlemen, and also MLA can be done not only based on treaty, but also can be conducted by non-treaty based cooperation, such as by reciprocity, diplomatic channel. This kind of cooperation need a comprehensive national law on MLA. Next. This is the legal basis of MLA in Indonesia, such as I explained before. This national law, bilateral treaty. We have some bilateral treaty on MLA, regional treaty, international convention, and also non-treaty based cooperation, based on reciprocity principle and good relationship. Next. This is MLA treaty that Indonesia, in Indonesia already adopted the MLA treaty, such as Indonesia and Swiss. Indonesia already ratify MLA treaty with Switzerland in law number 5 2020. And also Indonesia and China in law number 8 2006. Next.
Open
Next.
then. Open.
We go to MLA best practice of Indonesia. Yeah. In this occasion, I will present several cases related to asset recovery and non-asset recovery. Yeah, cover incoming and outgoing MLA. Incoming means another country that asks for the legal assistance from Indonesia, while outgoing is a case where Indonesia asks for legal assistance from another country. The first case is Jessica Wongso case. Yeah, this is not asset recovery case. Yeah, but just MLA generally. Maybe all of you, all the participants, yeah, as remember, Jessica Wongso case was quite famous, yeah, in 2016. In this case, Jessica was accused of poisoning her friend with cyanide spring in a glass of coffee. Jessica is permanent resident, yeah, in Australia. And when this case occurred, she was vacation in Bali, including the victim. Yeah. In this case, Indonesia requests MLA to Australia in investigation state and also in prosecution state. The MLA request from Indonesia successful, yeah, in this case, because Australian Minister of Justice gave permission to Australian police, yeah, to present at Jessica Wongso trial proceeding in September 2016. Next. Yeah, the second case, yeah, still this is not concerning asset recovery. Yeah, the second case is incoming. Yeah, if Jessica outgoing is incoming MLA concerning trading of protected wild animals in 2018. Yeah, in this case, is the Dutch foreigner arrested, yeah, for illegality trafficking protected wild animal. MLA request based on joint investigation between Indonesian National Police and Netherlands Police request to obtain witness statement and search the evidence, yeah, in suspect domicile in Bali, Indonesia. Finally, Indonesia hand over investigation document and evidence to Netherlands on August 2019. Next. Yeah, so we go to MLA on asset recovery. Yeah. Next. Yeah, I divide into outgoing and incoming MLA, yeah, in asset recovery. So for outgoing, there is to Singapore, to Jersey, yeah, also Hong Kong. I think the previous speaker, yeah, Pak Yuswiti already explained detail about this. Yeah, next. Yeah, this is still also in outgoing to Australia. It is also Papua, to Netherlands, yeah, and also to Switzerland. Yeah, I think I'm not repeat, yeah, the explanation from Pak Yusfitri already explained Pot Hendra Raharja case and others. And then next. Yeah, for incoming MLA request, yeah, for asset recovery, this is I give two cases here. The first is incoming from USA in case of MV Wise Anes ship 2018 and incoming from Malaysia in the case 1 MTB Economity Luxury Yachts. Next.
Excuse me, Prof. Sefriani, you still have 5 minutes.
Yes. Yes, ma'am. Case of MV Wise Anes ship 2018. Yeah, this ship is ship from North Korea, largest cargo ship. This was detained in Indonesia in Indonesian water. Yeah, in April 2018 and hand over 1 year later. Yeah, to US. This ship, yeah, was confiscated for violating UNSC resolution imposed to North Korea. The problem with this incoming MLA is that the violation of UNSC resolution, which are not criminal act, yeah, in Indonesia, yeah, because Indonesia have no provision how to adopt UNSC resolution in national law. Yeah, what about the position of UNSC resolution and our legal system is unclear. Next. Yeah, this is the second case as incoming case. Yeah, this is MLA. Yeah, incoming MLA case. This is 1 MTB and Economity Luxury Yachts case. Maybe my colleagues from Malaysia can explain this case more detail. Yeah, this case. Yeah, this equanimity is by Indonesian police in 2018 when it docked in Tanjung Benua, Bali, based on initiative of Department Justice of US. US believe that this yacht is mode of money laundering related to the corruption done by the former Prime Minister of Malaysia in 2009 in the project called as 1MDP, One Malaysia Development Berhad. Based on international cooperation among America, Indonesia, Malaysia, the yachts can hand it over to Malaysian government. Next. Yeah, this is the data for MLA incoming and outgoing year 2015 and 2020. Next. Yeah, this is statistic of incoming requests. Yeah, next. Yeah, we can see in 2017, this is the largest number of the requests, incoming MLA requests, 48 and complete 14 and in process 34. In 2020, 42 requests and complete 31 and in process 11. Next. Yeah, this is the statistic of outgoing requests. Yeah, next. Yeah, this is 2015. There are 28 outgoing requests. Yeah, complete 25 and process 3. 2020, there are 6 cases. Yeah, and complete. All of them is complete. Yeah, but sorry, I'm sorry about this data. I don't have more complete data. Yeah, for example, why was there is MLA was withdrawal pending? Yeah. I don't know about that yet. I just take from the internet, but I didn't know the detail about the data. I'm sorry about that. Next. The challenge MLA in asset recovery for Indonesia. Yeah, the challenges such as next. Yeah, the first challenge is for Indonesia is dual criminality principle. Yeah, this principle sometimes become the barrier of Indonesia to be successful MLAT. Dual criminality requirement will be met if the offense for with MLA is so punishable under domestic law of both requesting and requested state party. A number of countries still applying this principle strictly. So this has become the barrier, become the challenge. So maybe we failed to get the asset recovery. However, this principle may be set aside in bilateral MLA treaty. Next. Yeah, this is for the dual criminality test. Yeah, for example, a Nelo case. Nelo is former president director of Mandiri Bank in Indonesia. In that time, try to request of MLA to Switzerland, but unfortunately, it can be executed because the Swiss consider that violation of prudential principle in the provision of credit facility committed by Nelo were not considered as punishable act under the Swiss legal regime. This act does not categorize corruption, but only recognize as administrative infringement in Switzerland. Next. Yeah, the second challenging is just different legal system, due process of law, technical procedure. All of them is become maybe a barrier in the process of recourse of MLA in asset recovery, such as some country does not recognize the criminal liability of legal person, and will refuse to cooperate in this case. Some country require compliance to the procedure law very strictly. Next. Yeah, the third challenging is court order. Without court order, request of MLA but potentially will be refused. For example, MLA Indonesia delivered to the Switzerland to confiscate the Irawan Salim asset in Swiss bank was rejected because in fact Irawan Salim has not been convicted of any crime in Indonesian court. Next, this is the.
Yes, Prof. You have 1 minute left.
Yeah. Sorry. Next test of MLA. This is the challenge such as evident nexus between the crime and proceed of crime proceed of crime. And also tempus delicti. In many cases, Indonesia court decision does not cover the time for placement of asset abroad or only covered of the asset. So it's become the maybe the MLA request will be refused. And also there is other challenges. Many challenges. Next. is the last slide. Yeah, other challenges such as maybe requests that not cooperative, not responding our MLA request. Yeah, the tightness of banking financial system. Or where the assets are located, lack of resources, yeah, and yeah, many other challenges. Ladies and gentlemen, that what I can present. Yeah, maybe it can be sharpened to discussion. Pardon me for any shortcomings. Yeah. Then you thank you. Yeah, thank you so much for your kind attention. Okay, time as I will turn to Mrs. Sriwartini as the moderator. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Prof. You keep your time on time. Okay, so that's I would not make such kind of comment. Yes, I just give a comment that it was very interesting and comprehensive presentation, and also there are a lot of information that we can elaborate on the question and answer. Now we are going to go to Mr. Hanafi. So Mr. Hanafi is the senior lecturer of criminal law in Faculty of Law, and he is also the Vice Dean of Resources Faculty of Law. The title of his presentation is Asset Recovery and Mutual Legal Assistance in the Perspective of Criminal Law in Indonesia. Before he starts with the presentation, I would like to read the brief curriculum vitae of Mr. Hanafi. He graduated from Universitas Islam Indonesia for his bachelor degree, and he got the master degree from Universitas Indonesia, and the second master degree he got from Erasmus University of Rotterdam, and he got the doctoral degree from Erasmus University Rotterdam. So I think without further ado, Mr. Hanafi, you have your floor to have your presentation.
Okay, thank you very much, Mrs. Thank you very much for moderator. Good afternoon, everybody. Good afternoon, ladies and gentlemen. First of all, I would like to say keynote speaker, the Honorable Mr. Cahyo Rahadian, and the Honorable Rector of Universitas Islam Indonesia, the Honorable Dean of Faculty of Law, Universitas Islam Indonesia, and the Honorable all the distinguished speakers from Malaysia, Myanmar, and Hungary, and all the participants of this conference. Thank you for this opportunity to deliver my paper for this at this conference. My paper is in the perspective of criminal law. If Prof. Supriyani and Mr. Yusuf Lee deliver a paper from the international perspective, I emphasize on the criminal law perspective here. And first of all, I would like to present here that in this presentation, I emphasize on the corruption, as has been discussed before the previous speakers. There has been corruption is very dangerous in the world. Yeah, corruption has been exists in all in universal. It's universal. Yeah, it is exists not only in the developing countries but also in developed countries. Corruption also exists in the public as well as private sectors. And corruption also exists in non-profit and charitable organizations. In the previous time, corruption just in small perspective that corruption has been occur in the public sector. But nowadays, the corruption can also exist in the private and also in the non-profit organization. And as has been discussed before, that corruption is a transnational crime. Yeah, according Article 3 of the United Nations Convention Against Organized Crime, this convention qualifies corruption as a crime that can transcend national borders. Transcend national border, it means that there are more than one country involved in it. In this the case of corruption. So to coping with the corruption, it is also need more effort, yeah, because we have to make an agreement, make a cooperation with other countries here. And the problem of corruption as a transnational crime is related to the asset recovery and mutual legal assistance, yeah. And how about to overcome the problems of asset recovery and mutual legal assistance? International community, the UN Convention, the United Nations Convention Against Corruption, was established in 2003. Yeah, and one of the problem, one of the chapter of this convention is about the mutual legal assistance and asset recovery here. And also, Indonesia has ratified this convention in 2006 through Law Number 7, 2006. As the party of this convention, Indonesia has been reviewed by the international community, and the result of the review, there are 6 recommendations, and 2 of the recommendation is regarding the asset recovery and mutual legal assistance. So these two issue is very important in tackling money laundering and corruption in Indonesia. What about the data of Indonesia regarding the asset recovery here? During the period of 2001 till 2012, yeah, there are 704 identified assets. Only 20 assets successfully recovered. In total, Indonesia only managed to recover $3 billion US from potential more than $500 billion allegedly stolen assets. Now we turn to the legal framework of asset recovery. The legal framework of asset recovery here are emphasized on two legislation in Indonesia. The first one is the Corruption Act, and the second one is the Money Laundering Act. Yeah, the Corruption Act regulated in Law Number 3199, Contoh Law Number 20, 2001. If we look into this legislation, we can see that this legislation applies in persona model. In persona model means that it is follow the suspect. Yeah, follow the suspect. The important thing for this legislation is how to punish the perpetrator, not to return the asset. Yeah, the asset recovery just additional punishment, not the main punishment. So it is here in this. It is the problem of asset recovery in Indonesia based on this legislation. So in confiscation asset as part of criminal process, it combines conviction of the perpetrator and confiscation of the asset. And also this legislation also adopts civil suit to the proceeds of crime if the perpetrator is died. Yeah. And then the second one is Money Laundering Act. If we look into the legislation, this legislation follow the money. Follow the money in RAM model. There are 2 models of asset recovery in general, in persona model and in RAM model. So in Indonesia, for the money laundering, it follow the in RAM model. And in the model is it focus on the asset, not focus on the perpetrator. For example, here in Article 64 and Article 64 paragraph 1 and paragraph Article 65 paragraph 1, yeah, PPATK, which we call it financial intelligence units, yeah, conduct analysis of suspicious transaction related to indications of money laundering and other crimes. Here, the PPATK analyzes the suspicious financial transaction related to the indication of money laundering or other crimes here. And the second one, the PPATK may request financial service provider to suspend temporarily the transaction. It means that the financial intelligence unit or PPATK has an authority to request to suspect and also to suspend temporarily the transaction that it is the financial from the financial suspicious financial transaction. And then the third one, if there is no person or third party submit an objection within 20 days from the date of the temporary termination of the transaction, FIU will hand over the handling of the asset to the investigator to carry out the investigation. And the last one is in the event of the alleged perpetrator of the criminal offense is not found within 30 days, the investigator can submit the application of the district court to decide that those assets as a state asset and return them to the third party in good faith. So here, if in this legislation, Money Laundering Act, it is actually it is in REM model. They can follow the follow the asset than the suspect here. And how about the United Nations Convention Against Corruption? United Nations Convention Against Corruption requires the state to recover asset using the NCB. NCB is non-conflicted based method by fulfilling several the better dates, flights, and or other appropriate cases. So if we compare between domestic legislation, money laundering, and corruption act, we can see that it is in line with the United Nations Convention Against Corruption here. And then how about for mutual legal assistance in our country? And I compare to the UN Convention Against Corruption here. It is sometimes the obstacle to do the mutual legal assistance. There are three issues, yeah, that it is an obstacle to overcome or to carry out mutual legal assistance. I identified three issues here. The first one is the scope. The second one is the mechanism, and the third one is dual criminality principle. Here, law number 1, 2006, yeah, the scope is only in criminal proceeding. It does not accommodate in REM model. But if we compare to the UN Convention, yeah, UN Convention, it is accommodate
Excuse me, Pak Hanafi, you still have 5 minutes left.
Okay. The UN Convention accommodate MLA in terms of asset recovery. The scope is only in criminal proceeding. And the second one is about the mechanism. MLA cannot carry out directly by enforcement official, but by the Ministry of Law and Human Rights, a central authority. It is also sometimes obstacle for the law enforcement official to do mutual legal assistance with another country, because there is intermediaries with through the Ministry of Law and Human Rights as a central authority. And the last one is about dual criminality principle, as has been explained by Professor Safriani. Dual criminality principle, sometimes it is obstacle to carry out mutual legal assistance. For example, if it is not a crime from another state, we cannot carry out the mutual legal assistance. So the UNCIC allow excluding the application of dual criminality principle. So I think in the next future, I think we have to consider to eliminate the obstacle of these three issues: the scope, the mechanism, and dual criminality. through the UNCIC. Yeah, UNCIC has made it more flexible than before, not only for the scope, but also for the mechanism and dual criminality. So if every country sign and accommodate the UNCIC, I think it is very useful to carry out mutual legal assistance here. And it is several challenges to make mutual legal assistance in relation to the asset recovery. The first one is different legal system is an obstacle. The main obstacle to carry out mutual legal assistance and asset recovery. And the second one is the weak and capacity of the law enforcement agencies and other relevant agencies to carry out the work. I mean here, the weak is capacity, not only the number of the law enforcement agencies, but also the quality of the law enforcement agencies to carry out the work of asset recovery and mutual legal assistance. And the third one is lack of resources and trained personnel to deal with the asset recovery and mutual legal assistance. And the fourth one is the complexity of the asset recovery process. And the last one is low interest in countries where the assets are located. And for the last one, as we know that the asset use more asset from Indonesia usually located in developed countries. And as we know that the developed countries, for example, for the G8, G8 countries, half of the G8 countries doesn't ratify the UN Convention Against Corruption. So it is very how to say it? It is very sad, that the developed countries that they support the developing countries to be the party of the UN Convention, but they themselves doesn't ratify, doesn't sign the UN Convention of Corruption. And I think it is our notes for the next future to overcome these challenges. I think I think it's enough, Mr. Martini, and thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Pak Hanafi. And it was very interesting presentation, Pak Hanafi, and also detailed information regarding asset recovery and mutual legal assistance based on criminal law perspective. And hopefully that we are going to have discussion on with the audience. Now we are going to go to the next distinguished speakers come from Malaysia. We are going to have two speakers from Malaysia, Ms. Norina Bahudin, LLB LLM, and also Mr. Faizul Aswad bin Masri, LLB MCL. Mr. Norina Bahudin is Senior Deputy Public Prosecutors, Attorney General Office, Malaysia. So they are going to deliver about mutual legal assistance in criminal matters and recovery of proceeds of crime in Malaysian experiences. Hopefully that we can learn from Malaysia, how does it work, the mutual legal assistance and also the asset recovery regarding the criminal matters. Before Ms. Norina Bahudin, LLB LLM would start with the presentation, I would like to read the brief CV of her. She is admitted as solicitor and advocate of the High Court of Malaysia in 2000. And she got the bachelor degree in Bachelor of Law from her London School of Economics in 1998. And she got Certificate of Legal Practice, University of Malaya, 1999. And she finished her master degree in International Arbitration and Litigation from University College London, 2009. Okay, thank you. And because you have two people here, or two distinguished speakers, we are going to divide it the 20 minutes for the two people. Hopefully that you are going to have enough time to present your main idea of your presentation. Okay, the time is yours.
Thank you so much, Ibu Sri Wartidi, for that introduction. Assalamualaikum warahmatullahi ta'ala wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
My colleague, Deputy Public Prosecutor Encik Faizul. And firstly, we would like to thank Universitas Islam Indonesia for inviting us to be part of this presentation. May I just also extend my thanks to Pak Fatu Wahid as the rector of the university, and of course from Pak Chayo of the Ministry of Law and Human Rights. And may I also extend my welcome to fellow speakers who have come before me and who will be speaking after us from this talk. And of course, ladies and gentlemen, we hope to share with you the Malaysian experience insofar as mutual legal assistance is concerned and in the context of asset recovery. Now, if we recall at the very start of the keynote speech by our rector, Prof. Dr. Fatu Wahid, Prof has mentioned that one of the intention of this conference is to see the commonalities that can be gleaned from the different jurisdictions insofar as mutual legal assistance, or MLAs, such as I will refer them thereafter, the commonalities of the different jurisdictions on MLAs and asset recovery. And from the eminent speakers before us have talked quite extensively about the mechanism or the modalities in the Indonesian experience with regards to MLAs. And we find that insofar as what has been covered by our learned speakers from Indonesia beforehand, it is pretty much the same as the Malaysian experience. You know, when we talk about how evidence can be gathered, the different MLAs, which can be by way of treaties, either bilateral treaties or multilateral treaties, the manner in which cooperation can be extended even if there is no treaty, we find that insofar as the Malaysian experience, it is similar. So in that respect, we would like to hone in, or rather zoom in into areas of a particular nature, which is on the asset recovery aspect. And in this context, we would like to share the challenges that Malaysia has insofar as when it comes to talking about asset recovery. Now, the context of which that we will continue with our, before that, can I just very quickly apologize if I keep disappearing or appearing from the screen, because there are two of us. Sometimes the camera doesn't catch it. I might disappear or Faisal might disappear, but please bear with us if that happens. Now,
Okay,
as far as the contents are concerned, as it's on the screen, primarily we would like to start by talking about the parameters in which mutual legal assistance can be extended or offered in our country, as well as how it can, or how we do seek for mutual legal assistance from other countries. And we will also go into how we look into asset recovery in the context of this mutual legal assistance. Now, this has been covered by speakers beforehand, but of course, MLAs is meant to be very wide. It's intended for investigation, for evidence gathering, and in our law, at least, when we talk about recovery of asset, this comes under ancillary criminal matters, which includes enforcement or satisfaction of forfeiture order. Now, can you go to the next slide? Now, this is the key parameters from which the Malaysian experience, or rather the Malaysian context, is concerned. Insofar as mutual legal assistance, we are governed under the MAKMA Act. You can see that from our slide. It is the Mutual Assistance in Criminal Matters Act of 2002, and it is also buttressed or strengthened by the Mutual Assistance Criminal Matters Regulations. So these two statutes, or these two acts, governs how MLAs is to be extended or to be received by Malaysia. And when we talk about I've gone off screen, but we talk about the recovery of assets, this is primarily handled, or this is primarily in the realm of this is a mouthful, please bear with me, but it is the Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act. It is such a long act. We always refer to it as Amlat Fatwa, and even then it sounds a bit awkward. But these are, insofar as MLAs and asset recovery is concerned, these would be the two primary statutes that we will be referring to in the context of this presentation.
when we talk about the one of the when we talk about the main legislations which deals with MLA in Malaysia, which is the MAKMA. Section 3 of MAKMA clearly provides the object of the act for Malaysia to provide and obtain international assistance in criminal matters. And there are 10 objects listed in section 3 of MAKMA, but one of the objects which is relevant to our topic today on recovery or asset recovery is on subsection 3, sub C, which is on one of the assistance that we could obtain or we could assist is on the recovery, forfeiture, or confiscation of property in respect of a foreign serious offense. Okay. So our next slides, basically we are trying to share in the event we receive a request from a foreign country to enforce a foreign forfeiture order, to enforce a forfeiture order issued by a foreign country. So these are the main sections, the main provisions under MAKMA. So if you look at section 19 of MAKMA, this is basically the general provision which allows for Malaysia to consider a request from a foreign country. So we are going to explore, we're going to explain later on the important definition of prescribed foreign state. But as far as section 19 is concerned, it provides a general provision that Malaysia could assist foreign country. And if we look at the section 2 of MAKMA, this is basically a general section which provides legal definition on certain terms under the statute. So one of the terms is prescribed foreign state. So prescribed foreign state, according to MAKMA section 2, means a foreign state that is declared either by minister by an order under section 17, or declared or where minister has issued a special direction under section 18. So what is the difference between 17 and 18? 17 is applicable for a treaty partner. So for example, Malaysia and Indonesia, we are parties to the ASEAN MLA treaty. So the minister has prescribed Indonesia as one of the prescribed foreign state by way of an order. For section 18 is actually on case-by-case basis. For example, we have no treaty with Hungary, for example. So we can assist Hungary if the minister responsible for legal affairs issued special direction. So the act, MAKMA, will be applicable to the request from Hungary, to that specific request from Hungary. And the general powers and procedures to enforce a foreign forfeiture order in Malaysia as stipulated in sections 31, 32, 33, and 34 of MAKMA, as well as in regulations 22, 27, 28, and 29 of the regulations MAKMA. We are not going to, for the purpose of this presentation, we are not going to go into the details of the powers and procedures, but we are going to focus on one of the issues that we face in enforcing foreign forfeiture order. All right. is a very to enforce a foreign forfeiture order, we have to look at the definition of foreign forfeiture order as provided in Section 2 of MACMA. So it says that it refers to an order made by a court in a prescribed foreign state for the recovery, forfeiture, or confiscation of payments or other rewards received in connection with an offense against the law of that prescribed foreign state, or property derived or realized directly or indirectly from payments or other rewards received in connection with such an offense. Now, the next part is very important. That is made on or after the date of the order under Section 17 comes into force or after the date of special direction given by the minister under Section 18. So if we look at this definition, there is no problem, there is no issue for Malaysia to assist in enforcing foreign forfeiture order if the order is issued after the respective foreign state is declared as prescribed foreign state. But what happens if, when we receive the request from such a foreign state, that state has not been declared as a prescribed foreign state yet, but there's the forfeiture order has already been issued by a court in that foreign state. So that is actually an issue, a problem in for Malaysia to enforce such forfeiture order.
As my colleague Faizul has highlighted, the phrase prescribed foreign state is an important element insofar as assisting for other states to enforce their foreign forfeiture order. As was stated earlier in our slide, that the prescription by a minister can be done whether or not a fellow country is a treaty, has a treaty with Malaysia or does not have treaty with Malaysia. So because the underlying tenet or the underlying intention is of course to provide assistance. I mean, that is the whole spirit of an MLA, of a mutual legal assistance. It is to assist countries in their endeavors to of course generally in criminal matters, and in particular our conference, it is to assist in asset recovery. There's an echo somewhere. But so we, and so far as, of course, when we talk about a foreign foreign forfeiture order, as has been highlighted, and I believe Yusfidli in his earlier slide, he has painstakingly gone into the different stages of tracing evidence or tracing proceeds before it actually got to the stage of forfeiture. Now, in our case, when we talk about needing a prescribed foreign state before that country's or that foreign country's forfeiture order can be enforced or can be assisted by Malaysia to be enforced, usually that would be a case of a foreign country seeking Malaysia's assistance by way of an MLA to trace a certain property, or to freeze a certain property, or to seize a certain property. And all of this, of course, as we have seen from Yusfidli's earlier slide, these are steps prior to an actual forfeiture order. Now, in cases whereby foreign countries or foreign counterparts have sought our assistance in assisting to freeze or assisting to trace or assisting to seize, we are able to take steps to ensure that that country is a prescribed foreign state in order for us to give assistance. Thereby, once we have declared, or rather as per the requirement under our law for a declaration by the minister, once the minister has declared that that country is a prescribed foreign state, we are able to go through the different steps of tracing, of freezing, of seizing, before actually, if the foreign state has managed to obtain their forfeiture order, we will be able to then enforce that forfeiture order. Now this, as Faisal has pointed out, becomes a particular concern on the issue of on or after the foreign state is described as a foreign state.
Excuse me, you still have 5 minutes left.
Okay, thank you, Ibu. We will try to
Okay.
keep it within time.
Yes, sorry about that.
So if MAGMA is not applicable for that circumstances, under that circumstances, so there is alternative solution. Perhaps we could resort to the domestic legislation to assist in the recovery of that proceeds of crime. So one of the legislation that can be resorted to is the Amlat Papua, or the Anti-Money Laundering Act. In these connections, we can initiate domestic investigation with a view to freeze or seize the assets, and subsequently we can file an application under Section 56 of the Amlat Papua for forfeiture of properties where there is no prosecution, because like the main action here does not happen in Malaysia. So we can use the provision under Section 56, which is commonly known as the civil forfeiture proceedings. So under that civil forfeiture proceedings, the court will need to give a notice to interested to third party who may lay a claim against that properties. They have to attend the court on the date specified in the notice. They have to answer. They have to convince the court why the property shall not be forfeited, why the property should be given to them. So this is where the rightful owners of the properties, for example, the victims, can come and lay properties. If the satisfied, the property will not be forfeited. So we have a case study here that we would like to share with our fellow speakers and participants. We received a request from a particular country to enforce forfeiture order issued by that country. Unfortunately, the forfeiture order was issued first before we can prescribe that foreign state as a prescribed foreign state within definition of Section 2 of MAGMA. So the reason is because the accused agreed to voluntarily return the properties. So that is why the court in this particular case managed to issue such order in a very fast manner. So we have difficulty in enforcing the state forfeiture order. So what we do, or what we did, we launched our own domestic investigation. When we initiated proceedings, like I said just now, under Section 56 for civil forfeiture proceedings. So the victim entered into proceedings and filed a claim. The victim managed to prove, to satisfy the court that he had fulfilled all the conditions under Section 61. So after deducting the necessary costs, the properties were returned to the victim. So this is one of the case studies that we would like to share. And I suppose it comes to conclusion. Malaysia, we encourage foreign countries to send their requests to recover properties as soon as possible. If it is possible, to send the request before forfeiture order is issued by the court of that particular country, But if it's not possible, well, we argue that we still have rooms and space to enforce or to give effect to that order by using existing legislation in Malaysia. But we have to address the issue on the definition of the foreign forfeiture order. Perhaps it is timely for Malaysia to review the MAGMA and make a necessary amendment to MAGMA. That would be one of the best solutions to this problem. I think that will be all from both of us. We reserve questions later on. Thank you very much. I think
you're welcome. Thank you very much, Mrs. Nurina, and also Mr. Faisal Aswad bin Masri. So yeah, please apologize me that I have not read your curriculum vitae. So I would like to read your curriculum vitae for just a minute. Okay. Mr. Faisal Aswad bin Masri, LLB MCL. He is a deputy public prosecutor, a senior federal counsel at prosecution division. He got the Bachelor of Law from International Islamic University and also master degree for Master of Comparative of Law from International Islamic University, Malaysia. So we are the same alumni. Okay, thank you. So you know that we are going to go to the fourth speakers. Hopefully that I'm not mispronounce your names. Ms. Sri Wanmon, LLB, MCL, PhD. She is as Deputy Dean, Research and Industrial Collaboration Lecturer, Multimedia University, Malaysia. She is going to deliver his presentation on the mutual legal assistance and asset recovery under the legal system of Myanmar. Before she starts with her presentation, so I would like to read brief curriculum vitae of her. She has got the LLB from Dagon University, and she got the Master of Comparative of Law from Yangon University, and she got doctoral degree from International Islamic University, Malaysia. I think without further ado, so the time is huge. Thank you. You have also 20 minutes, and I would like to have a remaining time when 5 minutes left. Thank you.
Thank you, madam. Can you hear me? Hello?
Yes, I can hear you. It's clear.
Yes, thank you so much. First of all, very good. I think it's still afternoon. And Assalamualaikum to everyone, all the distinguished speakers and honorable guests, and also distinguished participants and all the lecturers and scholars and professors. And I'm also very grateful to be here today. And thank you so much for the invitation for this, to share my experience, to share my knowledge on this mutual legal assistance Myanmar's practice at this auspicious event today. So without further ado, I would like to start my presentation. My presentation will be on the practice of mutual legal assistance MLA in Myanmar, a brief analysis. So just a little bit of disclaimer that's to mention the limitation of my presentation. So my presentation will be mainly covered on the theoretical perspective and all the qualitative study and research materials that I found online. And as you all know that I'm currently in Malaysia, in the outside of my country, and all the details, like in terms of practical perspective, how the practical procedures being carried out for the MLA won't be covered in my presentations, but I'll be talking about all the legislation, legal framework relating to mutual legal assistance in Myanmar. So next slide, please. Okay, this will be my contents for the presentation today. Introductions, what is MLA, why we need MLA, and what is MLA. For the second point would be mutual legal assistance, and also international instruments which encourage mutual legal assistance. and a regional practice on MLA and referring to the ASEAN Treaty and Myanmar's practice, and at the end, the conclusion. Next slide, please. So now, introductions. So why do we need MLA? Why need to talk about MLA or extraditions? But extradition will be covered in my presentation. I'll be mainly focusing on MLA. So states are sovereign entities, and I think especially we Asians or ASEAN countries are pretty much, can say that we are quite conservative about sovereignty. So sovereignty is territorial in nature. Although a state may have a general power under international law to prescribe jurisdictions, the enforcement of that jurisdiction can generally take place only within its territory. So pretty much territorial in nature, and territorial jurisdiction, in terms of jurisdiction as well, territorial jurisdiction is the strongest type of jurisdiction. So if you can refer to the Lotus case 1927. So prescriptive jurisdiction versus enforcement jurisdictions. If we want to compare these two, enforcement jurisdiction is more limited in nature. So now that's the reason why, in order to enforce the law, or in order to exercise the jurisdiction of the country without burials, or to overcome, in other words, to overcome the jurisdictional burials in suppression of transnational crimes, we need this actions or initiative called MLA, mutual legal assistance. Next slide, please. So mutual legal assistance, what is mutual legal assistance? It refers to the provisions of legal assistance by one state to another state in terms of generally three procedures, which is investigation, prosecution of, punishment of criminal matters. And MLA is necessary particularly for suppression of transnational organized crimes, such as trafficking in persons and drugs and smuggling in persons. And MLA is generally governed by bilateral or multilateral legal assistance treaties that regulate the scope, limit, and procedures for such assistance. And however, one point to bear in mind is that treaties are often supplemented by domestic legislation. So in terms of the practice of MLA, we can find that domestic legislations are pretty much given the priority. And MLA can also be done informally in case of the absence of bilateral cooperation or the multilateral treaty. It can be done via diplomatic channel among the authorities by sharing of information among the policing or judicial officials in different states. Next slide, please. So there are some international regional crime conventions that I mentioned here, which address the issue of MLA and encourage MLA. Most international and regional crime conventions contain provision on mutual legal assistance. So for example, some of the regional conventions would be Arab League Conventions on Mutual Assistance in Criminal Matters, and Inter-American State Convention on Mutual Legal Assistance in Criminal Matters, European Convention on Mutual Legal Assistance in Criminal Matters, and for UN Model Treaty on Mutual Assistance in Criminal Matters, and United Nations Convention Against Corruption, particularly Article 46 address MLA, and UN Convention Against Transnational Organized Crime and the protocols. Article 18 particularly address MLA. Next slide, please. So now I would like to take an example of UNOTC on what type of crimes is subject to, in case of what types of offense or crimes happened, we can call for this kind of mutual legal assistance. According to these conventions, UNOTC, the crime should be the serious crime. So what does it mean to be the serious crime? Serious crime shall mean conduct constituting an offense punishable by the maximum deprivation of liberty of at least 4 years or a more serious penalty. And it also must be the nature of the crime must be transnational. So an offense is transnational in nature if it is committed in more than one state, or it is committed in one state, but a substantial part of its preparation, planning, direction, or control takes place in another state. For example, like drug trafficking, human trafficking. And is committed in one state, but involves an organized criminal group that engages in criminal activities in more than one state. So by looking at these provisions, we can see that the nature of and the types of crimes subject to this mutual legal assistance, the nature is that it has to be the transnational in nature, which involves more than one jurisdiction. Next slide, please. So this is the article or provisions under the UNTOC on MLA. So it says that state parties shall afford one another the widest measure of mutual legal assistance in terms of investigations, prosecutions, and judicial proceedings in relation to the offenses covered by this convention as provided for in Article 3, meaning that it has to be the serious crime and it has to be the transnational in nature. The nature of the crime. Next slide, please. And if we look at this, even for these conventions, Article 4 provides the provisions on protection of sovereignty. So we can see that how sovereignty is protected, even under international law. So state parties should carry out their obligations under this convention in a manner consistent within the principles of sovereign equality and territorial integrity of states, and that of non-intervention in the domestic affairs of other states. So by looking at this international convention and these particular provisions, we can say that although this convention encourages the mutual legal assistance, we also have to bear in mind that, you know, we have to respect the sovereignty or territorial integrity of the country. So that's the reason why, if I have to refer to the previous distinguished speakers, also mentioned that political will is very important. Regardless of how many agreements we have, conventions we have, initiative we have, at the end of the day, political will matters most. Next slide, please. So now, after we look at the international general overview of the international instruments, if we look at the regional level, of course, ASEAN practice, since we are all the members of ASEAN, we have Treaty on Mutual Legal Assistance on Criminal Matters 2004. And this convention does not allow any reservation. So it's like a package deal that if we have to, we sign, then we have to agree with all the provisions in the treaty. So under this treaty, the parties shall, in accordance with this treaty and subject to their respective domestic laws. So we can see again, this regional treaty also gives priority to the domestic law of each country, render to one another the widest possible measures of mutual legal assistance in criminal matters, namely investigation, prosecutions, and resulting proceedings. And this treaty prohibits a party in the territory of another party the exercise of jurisdiction and performance of functions that are reserved exclusively for the authorities of that other party. So we can see that this provision, Article 2, Sub 2, specifically protect the sovereignty of each member's country as well. Next slide, please. Okay, so now this is the major part of my presentations, mutual legal assistance, Myanmar's practice. So if we look at the Myanmar's practice, of course, the materials available online is pretty much limited, but I could get the original legislation on mutual legal assistance in Myanmar. And I also found that since this, the theme of this conference itself also covered the assets recovery, and I'm surprised that there is no provisions mentioned under the main mutual assistance in criminal matters law 2004. Instead, I found some other documents which is separate from the legislations, which I will also explain during my presentation. So mainly, I will start with this mutual assistance in criminal matters law 2004 from Myanmar. So the legal basis, the most important point here is that Section 3A provides that offense means the offense punishable with imprisonment for a term of 1 year and above. So minimum penalty has to be 1 year in order to request Myanmar for the mutual legal assistance under any existing law in Myanmar. The third expression also includes offense punishable with imprisonment for a term of 1 year and above under the law of any requesting foreign state. So it explicitly mentioned that it is very important to ensure the double criminality requirement in order to request mutual legal assistance to Myanmar. MLE may be granted on the basis of an international convention or multilateral or bilateral treaty or reciprocity. So a foreign country can request MLE to Myanmar authorities for MLE based on international conventions. It could be multilateral or bilateral, or in the absence of multilateral or bilateral treaty, it can come to the diplomatic channels. Next slide, please. So now, what is the most authoritative or responsible body in terms of MLE in Myanmar? Is the central authority. It's called central authority. So the government shall form the central authority for rendering assistance among states in criminal matters, comprising the following persons. So I won't read everyone, but of course we can see this. The chairman is the Minister of Ministry of Foreign Affairs, Ministry of Home Affairs will be in charge of MLE assistance, legal assistance matters. Next slide, please. Okay, so now in terms of dual criminality, we can see that Myanmar practice strict dual criminality, including for non-coercive measures. A minimum 1 year imprisonment punishment requirement applies. So this sentence, I found it, I quote the documents I found online, with the exception of Myanmar. If I'm wrong, you can correct me. I don't have the data that this information is updated or not, but this document claims that with the exception of Myanmar, all ASEAN states apply conduct-based dual criminality as required by Article 43.3 of UNCAC, such that they only require the conduct of the suspect or convicted person, acts or omissions to constitute an offense in the requested and requesting states, rather than requiring the offenses to use the same terminology or fall within the same category of offenses. So it clearly says that with the exception of Myanmar, so it seems like all the other ASEAN states except for Myanmar are a little bit more maybe flexible in terms of dual criminality. Maybe we can further discuss on this during the discussion sections. Next slide, please.
Okay, excuse me, 5 minutes left.
Okay, thank
Ms.
you.
Suwais.
Thank you.
Okay.
Yes, thank you. I'll make sure I'll be on time. So,
Thank you.
okay, these are the important points that I just extract from the legislation. So I won't go into detail because this is all from the legislation itself. Rather, I will just give the overview, the attitude of Myanmar towards the cooperation and collaboration in terms of MLE activities. So may I skip this slide, please? Next slide, please. Okay, so in terms of consultation, Myanmar will always request additional information required in order to perform these MLE activities successfully. And procedure, normally Myanmar will follow the procedure specified in the request unless it conflicts with domestic law. Next slide, please. Okay, costs, Myanmar will pay the ordinary costs associated with the request, but other costs are determined by agreement. And postponement of assistance, whenever it is necessary, Myanmar may postpone the assistance. And in terms of return of assistance, in terms of the documents, records, and property, it will be handed over on condition that they be returned once no longer necessary for the purposes of the request. Next slide, please. Okay, so in terms of, before I conclude my presentations, I just want to highlight on the assets recovery. It is not covered under the MLA 2004 legislation, but instead the most authoritative authority or responsible authority in terms of assets recovery would be Minister for Foreign Affairs. And Minister of Foreign Affairs provide informal asset tracing or investigative assistance to a foreign jurisdictions. And there are some list of jurisdictions, legal framework for mutual legal assistance for asset recovery. Let me just read quickly. Criminal Procedure Code, 1898, Criminal Enactment Law, Amendment Law 1951, the Law Against Unlawful Possession and Procurement 1986, Mutual Legal Assistance on Criminal Matters 2004, Anti-Corruption Law 2013, Anti-Money Laundering Law 2014. So these are the laws related legislation for the asset recovery in Myanmar. So if we look at the overview of my presentations and the practice of Myanmar, so UNODC conventions to which Myanmar is a party. Yes, Myanmar is a convention to UN, a party to UNTOC and also UNCAC. So implementation, Myanmar is the dual, practice the dual system because we need to implement by passing the laws by Myanmar Parliament for the domestic implementations of international law. So we have domestic implementation. In terms of domestic implementation, we have Mutual Legal Assistance Law 2004, and for the UNCAC, we have Anti-Corruption Law 2013, which they repealed the old law, which is 1948 Suppression of Corruption Act. So in terms of bilateral treaties, we have Mutual Legal Assistance Treaty with India in 2010. So if I have to give my own comments based on my research, so most of Myanmar legislations are outdated. As you can see that most of the legislations are from 1990s. And there is no implementation at the domestic level, although sometimes for most of the time we can say that, there is no effective implementation at the domestic level after they become party to the international convention. So I conclude that there are rooms for improvements in terms of effective implementation of international law, of course, including mutual legal assistance and asset recovery. Thank you.
Thank you, Dr. Laiman. So that's you still have 2 minutes. But thank you very much for your interesting presentation and also detailed and comprehensive presentation, so that the audience can learn what you have already presented. So now we come to the last presenters, but is also a distinguished presenter, of course. That she is coming from Hungary. So Dr. Skalba Kondola. Before you present your paper, I would like to read your brief curriculum vitae. No, presently that she has a doctoral degree from the University of Dresden and for undergraduate legal studies in Catholic University of Leuven, Belgium, and also as the University of Coimbra as the fellow researchers for constitutional law and fundamental rights, and in the University of Vienna, Austria, for undergraduate of legal studies in the international human rights law, European Union law, and also US private law and Australian administrative law. And the complete curriculum vitae will be available on the chat room. Okay, so without further ado, you know that the floor is for you.
Thank you very much. Thank you for the kind invitation. I'm very pleased to have this opportunity to present in this great international conference, and especially thanks for the university for organizing this. And I'm really privileged to present after this the prestigious and distinguished set of professors. This time, unfortunately, not in person due to the pandemic, but hopefully we'll soon get back to normal way of life and meet each other once again. The topic of the conference is very relevant and especially complex, and I'll give you my perspective on this matter as a doctoral candidate dealing with international and European law. First, I will give you a short introduction, then we'll sketch up the applicable laws and legal framework, and I'll break down this into several sections, namely the presentation about the domestic law applicable in Hungary, the international law that has multiple segments as well, and European Union law. Not sure if you see my PPT.
Not yet.
Okay. Is there any way to put it in? Well, Anyway, I will then continue. Of course, cross-border criminal activities, especially organized crime, serious crime, money laundering, terrorism, and financing terrorism is a great challenge to many of the countries, as we also heard from the previous presentations. This because of harmful activities infiltrate the legal economy, as well as causing tremendous damage to the society. Therefore, the confiscation, the freeze, and the recovery of criminal proceeds or illicit assets is an essential component in the fight against these crimes. This requires states to cooperate with each other and exchange information, and to cooperate in the asset recovery process. Action must be taken by governments and authorities to deprive criminals of their financial gains, and to ensure that crime does not pay. Crime does not pay is actually kind of like the slogan, the European.
No, you have become the co-host so that you can share your PPT.
Hold on for a second then. You see it now?
Yeah, the committee told me that you are not the co-host, so that you are going to be able to share your PPT.
Sorry, I couldn't hear you now.
The committee told me that you are not as a co-host, so that you can share your PPT.
Okay.
Okay.
Do you see it now?
Yes.
Perfect. So may I just continue with the introduction?
Yeah, sure.
You see the PPT properly now?
Yes.
Great. So I was just finishing up with kind of like the slogan of the European Union, that is the European efforts that crime does not pay. Then I'll just go from here with presenting the legal framework, the domestic, the international, and European law, and we'll conclude on after the presentation. So from the Hungarian perspective, we are talking about the multi-layered system in asset recovery and MLA. This is because we have the European Union as well as other international systems or regimes where we cooperate with these countries, and these systems are having a slightly different uptake and come with different commitments as well. From our perspective, we can make a sharp distinction whether the partner country is a member state of the European Union or not. Therefore, in Hungary, we have to deal with an extensive national legislative system, classical international set of norms, and plus the European criminal law domain. And within the international law, we have to highlight the Council of Europe, which is another system. It's really a complex, multi-layered, and sometimes it's having a serious overlap between these regimes, but always the best forum should be picked in order to facilitate the question. I would go with the primary laws first. The domestic law in Hungary is based on the Act of International Legal Assistance in Criminal Matters. This is dated back from 1996, and this piece of legislation is to regulate the international assistance with Hungary's international partners. This is kind of like a background law that is only applicable if other international treaties or agreements do not provide otherwise. According to this law, requests for assistance can only be satisfied as a matter of principle if the act is considered to be a crime in both of the countries, of course, involving Hungary and the requesting country. In addition, if the act in question does not qualify as a political or military offense, a request for assistance can also be denied if it would infringe the country's public order or national security interest. Of course, the relevant authorities and ministries always investigate the question and decide accordingly. If any of these elements are not met, then Hungary will not comply with the request, or at least can deny the request itself. This is kind of like the domestic framework as a background, but of course we are cooperating with other countries at the international level. So I would next I would go and sketch up the international dimension. Of course, Hungary is a party of many universal conventions, or almost universal conventions. Hungary also implemented several well-known international norms in this question, as well United Nations conventions and Council of Europe conventions as well. On the PPT, you can see the most relevant or the well-known conventions. What we are party: UN conventions against illicit traffic in narcotics, Convention on Laundering, Search and Confiscation, the UN Convention against transnational organized crime, UN Convention against Corruption, and Council of Europe Convention on Laundering. I just highlight that the Council of Europe is an international organization similar to ASEAN, basically. And this is distinct from the European Union. It's a multilateral international organizations. Many of these UN and Council of Europe conventions have been ratified by both the member states itself, the European Union member states, and the EU itself as a party. And of course, Hungary also signs bilateral agreements if any of the countries in questions are not member of this framework. What might be the most interesting part and the most distinguished part from the Indonesian and Malaysian perspective is the European Union law. According to the European strategy, confiscation is a strategic priority in the EU's fight against organized crime. Which is reflected in its internal security strategies as well. According to the Europol, which is basically the European version of the Interpol, more than 5,000 organized crimes groups are currently under investigation in Europe. So it is a great challenge for us as well. Therefore, we need solid legal foundations to fight against these organized crimes. The foundation of the EU-wide mutual legal assistance rests on basically two norms. You can see on the slide. One is a directive that is directly implemented in the countries within a set of period of time, and the regulation that is directly applicable in all countries without implementing to the national law. As you see, the directive, the directive 2014-42 EU on the freezing and confiscation of instrumentalities and proceeds of criminal crime, and the European Union sets minimum rules for freezing, management, and confiscation of criminal assets, and establishes a process with several phases, including identification and tracing of illegally acquired assets, freezing of the assets with the view to their possible subsequent confiscation, management of frozen and seized assets to preserve their value, actually, confiscation of illegally acquired assets, for example, and disposal of the confiscated assets, or even reuse the assets for public or social purposes. Example for this latest, the latter one, the reuse. Hungary reused high quantity of alcohol last year to that was confiscated to actually produce hand sanitizers due to the pandemic. There is a regulation 2018-1805 on the mutual recognition of freezing and confiscation orders. This regulation is a significant milestone in the area of asset recovery. It aims to facilitate cross-border asset recovery and make the freezing and confiscation of criminal assets across the EU quicker, more effective, and simpler. It applies to all freezing and confiscation orders issued within the framework of proceedings in criminal matters, including conviction and non-conviction based confiscation as well. The EU regulation, as I said, directly applicable, so it's applicable regardless of implementation into national law. Moreover, to this set of norms, I should highlight a Council decision from 2007 that obligates member states to set up or designate a national asset recovery office in order to ensure the fastest possible EU-wide tracing of illicit assets. This is basically a network of authorities within the European Union, which play a significant role in tracing of proceeds and illicit assets. And we can also consider as a good practice in the European Union that the European Commission launched an informal platform for further enhance member states' EU-level cooperation, so that authorities and this asset recovery offices can share their knowledge and their practices within this platform. These provisions on the exchange of international and mutual legal assistance have been successfully used in a number of cases because it requires member states to put in place robust freezing and confiscation measures and to make them able to cooperate or recover assets. These ensure that national authorities can fully prepare and to carry out their task and combat organized crime as well. Compared to the international systems or international frameworks within the UN or the Council of Europe, it can be concluded that the European Union framework is more effective, less formalistic, less bureaucratic, and therefore typically take less time to conclude and effectively stand up. Then I would
Excuse me,
just turn
Dr.
to...
Skaba. Oh, you still have 5 minutes.
Perfect, thank you very much.
Okay.
Try to use this time as effectively as I can. So I'm would conclude that in the recent years, the EU has made considerable efforts to assist financial investigation and harmonize the legislation on confiscation. The adoption of the directive especially has led to substantive progress in the member states' set recovery framework. 24 out of the 27 member states of the European Union bound by this directive adopted new legislations since 2014. So they to make sure that their domestic legislation is up to the highest standards and up to the requirements of the directive itself. As mentioned earlier, we are dealing with the multi-layered system. The heart of the MLA rests on the European Union for the member states, and of course the Council of Europe norms, as well as other international conventions. However, if those prove to be ineffective or insufficient, there's always a room or always a possibility for bilateral agreements. In absence of all of these, domestic law as an underlying legal framework is still available. Naturally, the more effective a system, the better. However, all of these contribute to the overall goal that crime does not pay. Thank you very much. I would finish it up at this point. Thank you for your attention.
Thank you very much for on time that you presented your main idea here, so that we have already learned a lot of information from the six distinguished speakers, so that we can share and also discuss this kind of question when we are going to ask more elaboration of each state regarding the best practice and their experience regarding mutual legal assistance and also asset recovery. And thank you very much for all the distinguished speakers. Now we are going to come to the question and answer. And I have already have one question will be addressed to Pak Hanafi. Maybe Pak Hanafi already read the question to save the time. Pak Hanafi, have you read the question?
Yes.
Yes, okay, so that
yes,
you can directly...
I have read the question. Yes,
okay, so you can directly answer the question.
Actually, there are two questions here for this question. The first one is about the harmonized and interrelated arrangement regarding the seizure of asset of corruption suspect, who is also suspected of committing money laundering from the perspective of Indonesian criminal law. After we look into the regulation, the legislation of criminal corruption and money laundering, there is no regulation at this legislation regarding the confiscation of asset or the perpetrator of the money laundering and corruption. And the principle of criminal law, if there is no regulation in this special criminal law, we can refer to the general criminal law. General criminal law here is the Criminal Procedure Code, KUHAP, yeah. In the KUHAP, in the Criminal Procedure Code, there is a regulation about the confiscation of asset from the perpetrator of the crime. Yeah, so it is. I repeat again. There is no regulation in the special criminal law, but we can refer to the general criminal law that it is the criminal procedure code in KUHAP. There is regulation about how the investigator or the prosecutor to confiscate the asset of the perpetrator that obtained from the crime. It is the first question. And the second one, it is about the indicator, yeah, the indicator of the KPK, consideration of the KPK investigator in confiscation asset the corruptor, whose value is considered undiscernible. So the consideration of the KPK to confiscate the asset from the perpetrator is starting from the tempus delicti of the crime. Yeah, the tempus delicti of crime. If the crime of corruption has been occurred in 2021, so or in 2020, for example, so the asset that can be confiscated is starting from the 2020, not the before the tempus delicti of the crime. But in reality, in Indonesia, KPK investigator confiscate all asset before and after the time of the crime has occurred. So it is the reality. It is very fitting actually, but it is the reality in Indonesia. I repeat again, the starting of the tempus delicti can be confiscated by the investigator that has obtained from the crime, the asset obtained from the crime. It is my answer.
Okay, thank you, Pak Hanafi. If the participant would like to ask directly to the speakers, so know that you have time now. So we are going to have 20 minutes. So we still have 20 minutes to question and answer. So if there are some participants who would like to directly ask questions to the speakers, so the time is yours. Yes, anyone would like to ask question to the speakers? No response? Well, if there is no response from the speaker, so I would like to request each speaker to have the concluding remarks. It may around 2 or 3 minutes to have your concluding remark. Thank you. It will be the first. Who's going to be the first? Okay, so that we are going to have the first here is Prof. Sefriani, maybe you are going to be the first to make a concluding remark.
Okay, maybe my concluding remark is the first is it is very important to Indonesia to increase the number of bilateral MLET, yeah, which state that Indonesia has big interest in asset recovery. The second one, it is time for Indonesia to focus on MLA asset recovery, yeah, because it based on the follow the money concept to maximize asset recovery. And the last one, it is very important also for the government to increase capacity building of the human resources, yeah, increase the capacity building of the all parties involved in the MLA process to prevent the rejection, yeah, of outgoing MLA from Indonesia just because of maybe unnecessary technical problem. Okay, it is enough, Bu Sri Wartini. Thank you.
Okay, thank you, Prof. Sefriani. So the second here is Pak Yusuf Sidrin. Would like to give your concluding remarks. Thank you.
Thank you very much, Ibu Sri Wartini. My remarks is at the end is that I think we still need to study and exchange views on this area, the asset recovery, because a lot of issues and also a lot of topic have not been elaborated or explored for further study. For instance, now we need to move forward on the effort to pursue asset recovery, but I think some people would agree that MLA is not an effective way to recover the stolen asset yet. So that's why the UNODC in Vienna and also the World Bank through the Stolen Asset Recovery Project, the STAR project, still make further study on the, for instance, the implementation or the applicability of foreign court order in in a jurisdiction. So our colleagues from AG's chambers Malaysia also mentioned about these foreign confiscation or foreign forfeiture order. So this is one area that is being studied by UNODC and the World Bank and the other experts. And the other developing area in this context is, I think, the connection between the foreign direct investment and the other the other treaty on investment with the arbitration. So this is also, although it's not directly related to the asset recovery, but it will be useful to study more on the effectiveness or the feasibility of having better mechanism as an alternative to mutual legal assistance. And exchange views between legal practitioners, asset recovery practitioners, and also between academias from one jurisdiction to other jurisdiction also is a good one to improve the situation in the context of MLA and asset recovery. And I think we also not to forget the importance of improving our legal frameworks. For instance, Pak Hanafi, in responding to the question, highlighting about the money laundering investigation, when the asset found actually has nothing to do with the tempus delicti, the crime occurred. So this is also still debatable, whether the investigators from the KPK has jurisdiction to ask a seizure and also confiscation of those kind of assets that are suspected to be a money laundering of a convicted person of a corruption case. So we need to improve the legal frameworks. And I think lastly, also we need to strengthen informal cooperation, because it's a good one to acquaintance yourself with your colleagues from other jurisdiction, with your counterparts from other jurisdiction, but also to exchange views with the people from different background, different legal background and different asset recovery practice background. Thank you, Ibu.
Okay, thank you. So actually there are two people who raised hands, so I would like to ask permission from all the speaker. Is it possible that we are going to have the two questions from the two people? I would like to ask your permission for all the speaker. Is it possible?
Okay, Bu.
Okay, so we are going to have two questions. Two questions. Please, Ahmad, we would like to ask questions. So please, the time is yours. Ahmad, yes.
Yeah. Thank you for the opportunity. First of all, I'm a student in University Islamic of Indonesia, and my major studies law. And according to Mr. Hanafi Amrani's statement before, it's called crime is always developed and the law is always left behind. So my question is it possible to adopt a principle or norm called retroactive of law to face the crimes that are always developed? Yeah, that was my question. Thank you.
So would you like to repeat your question in the last part?
Okay, so my question is it possible to the country, especially from Indonesia, Malaysia, Myanmar, and Hungary, to adopt a principle or norm called retroactive of law or retroactive of justice? So as we know that
Yes.
almost, yeah, that was my question. Thank you.
Okay, Pak Hanafi would directly to respond to the question.
The question is it possible for our country to adopt retroactive principle? It is not possible according to the asas legalitas, yeah, legality principle. We cannot adopt the retroactive principle because in our country we uphold the legality principle. So it is not possible in the perspective of the legal framework and the perspective of the legal principle in Indonesia. It is my answer.
Okay, thank you, Pak Hanafi. See one more question, or that's only one? Because previously I know there are two people, but no, if there is no more question, I would like to go to Ms. Norina and also Mr. Faisal Aswad to give the concluding remarks. Yes. You unmute first. Unmuted. Not. Please. Yeah. Okay.
I apologize to the rest of everyone, the rest of the speakers. Our concluding remarks is that we had hoped from today's conference that we were able to share Malaysia's experience in how we assist other countries insofar as asset recovery is concerned. Legal assistance comes in. We also find that we are very grateful to the knowledge that's been shared by colleagues around the table in this presentation. As I've said when we were doing our presentation, the whole spirit of mutual legal assistance is to ensure that countries try as far as they can, either within the framework of the domestic law or other ingenious ways in which they are able to assist each other in getting evidence, in assisting in investigation, and in enforcing foreign judgments received from other countries.
Thank you. Yes, continue with Mr. Faisal.
I have nothing much to add. Actually, I agree with my learned sister. We enjoyed very much this session. We learned a lot from our co-speakers, and we look forward to perhaps future invitation for similar engagement. Thank you.
Okay, you're welcome. So now we are going to go to Dr. Seweman to give the concluding remarks. It's the time for you.
Thank you so much, Madam, for giving me the opportunity for this concluding remarks. And first of all, I would like to say that I feel grateful to the organizer for giving me this opportunity. And I would like to say sorry if I shared, that the information that I share is very limited because it's very theoretical and it is only based on the information that I could find online. And I found that this is this event and this section, the whole conference is a very interesting session. And I learned a lot, actually. I've learned a lot because the practitioners who like from AGC, from Malaysia, and also Indonesia, share the very detailed procedures from the practical perspective that sometimes we cannot just learn and reading online. So this is a very good opportunities given to me just to share my limited knowledge as well as to learn from all the learned speakers. So as I have mentioned in my presentation, at the end of my presentations, in fact, in case of my country, we still have a long way to go to make up and to keep up with all the international legal developments, and also to update our domestic laws. And in case of this access recovery, we don't really have the specific guidelines prepared on this yet. So I think Myanmar has still, there are many rooms for improvement in terms of this mutual legal assistance and asset recovery. So with that, I would like to say thank you and stay safe. Assalamualaikum.
Okay, you're welcome. Waalaikumsalam warahmatullahi wabarakatuh. Now we are going to go to Dr. Skaba. Please, your time is yours, Dr. Skaba.
Thank you very much for the invitation as well, and thank you for the opportunity. We heard a lot of useful information during this session. I would sum up with the part what I tried to sketch up. In Europe, it is fair to say that there is a highly harmonized system between the 27 states of the European Union, but still there is room for further enhancement of the framework, of course, and to cooperate even more closely with our international partners as well, and to come up with a much more comprehensive international framework that or a set of law that is able to facilitate the MLA in a quicker and more effective way. So thank you very much once again for having me here.
Okay, thank you very much, Dr. Skaba. No, that's the last distinguished speaker. Pak Hanafi, would you like to give your concluding remark?
Okay, thank you. My concluding remark is we have international convention, a lot of international convention regarding the asset recovery and mutual legal assistance. And we have also domestic legislation. We have also bilateral and multilateral agreements. And almost each country has ratified the international convention, but we still have any problems in conducting mutual legal assistance and asset recovery. What is the problem here? In my opinion, the key to all this problem is the strong political will of each country. So it is the problem. The key problem is the strong political will of the country. If the country has a political will, political interest to cooperate and assistance to each other, I think everything of this problem can offer. It is my concluding remark. Thank you.
Thank you. So thank you for all the distinguished speakers. So this is the end of our discussion. So from the discussion, I cannot conclude by myself, but each person here has its own conclusion. And may I conclude for myself that each state has its own opportunity and own challenges how to cope up with this kind of performing legal assistance and also asset recovery. And it made the feasibility how to cope up with this kind of problem that bilateral agreement, it may be feasible how to cope up with this kind of problem. Okay, thank you very much for all the respective participants that you all are patient to join with our conference today. Thank you very much, and also thank you very much for all the distinguished speakers. And I would like to defer to the Master of Ceremony, and I'm as the moderator. If there are many mistakes during I lead this kind of discussion, please apologize me. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. Applause for all of us. Okay, thank you.
Thank you for Dr. Anda Sriwardini SH, PhD. So once again, Ladies and gentlemen, please give applause to our speakers and moderator. For the committee, please spotlight my video because some participants still doesn't see me. Okay, ladies and gentlemen, now we have come to the end of the agenda. Before we close our agenda today, we would like to invite all the speakers, the respective moderator, and the head of the committee also from the study program, the secretary of international program, and the secretary from regular program to have photo session. So please turn on your camera and the committee will help me to have the photo session. Kami mengundang kepada para pembicara, moderator, pada ketua panitia, dan juga dari perwakilan dari Prodi, kepada sekretaris program internasional dan sekretaris program reguler untuk ada foto bersama, sesi foto bersama. The committee, please help me for the spotlight, please. Please spotlight to all the speakers and also the moderator. And to Aruma Elmina, we invite you to open your camera to the photo session. And also Pak Ari Wibowo, to Mr. Prodi Setiawan. Okay, we apologize for the technical problem, but the committee will help us to the photo session. Also to Mr. Bagia, Secretary of Department of Faculty of Law, Universitas Islam Indonesia, Mbak Nur Kemilang, also one lecturer and the interpreter for our session today. Okay. So please look at the camera and give your best smile. I will count to 1, 2, and 3. Okay, once again. So 1, 2, and cheese. Okay, thank you, everyone. So for the next session, I would like to invite all the participants to turn on your camera, but because of the time is against us, so I would like to have photo session to all participants who turn on their camera, turn their camera on. So please, to all the participants, we have 2 rooms. Okay, so waiting for the another participant. Actually, we have around 200 participants, but I'm not sure they are all available to open their camera. Okay, for the first room, so 1, 2, and 3. We're going next to the second room. So, okay, 1, 2, and 3. Thank you, everyone. Now, ladies and gentlemen, Now we have come to the end of the agenda. Let me close our event with recite Hamdalah together.
Alhamdulillah.
Alhamdulillahirabbil alamin.
As the name of committee, we would like to apologize if there were any mistakes from our performance conducting to this event today. I'm Rahadian Suartono. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
Waalaikumsalam warahmatullahi wabarakatuh.
Warahmatullahi wabarakatuh.